Good afternoon, everyone. It's 5 to 2. We're just waiting for everyone to join, so we'll probably start a few minutes late. I would say at 2:05, just to give everyone a chance to come in. So, uh, time to make a cup of coffee or cup of tea and something to eat if you want to, and then we'll join Professor Jackie in about 9 minutes 5 past 2. Thanks. Those of you who just joined us, we intend to start at 5 past, just to allow those who are still trying to join within the next 5 minutes. We will start promptly at 5 past. If you take this time to just prepare yourselves, make yourselves a cup of tea or whatever you need to do, and we'll be back with you at just before 5 to, and we'll start at 5 past. We'll start at 5 past. Thanks.
How's it, everyone? Welcome to. We still about only got half the amount of people in so far, so we're just going to give another couple of minutes for everyone to join. I'm still having people phoning me to struggle. All right, so yeah, just bear with us.
Right, so a minute to go. Welcome, everybody. I'm sure you're all looking forward to another texting session with Prof. Jackie Arendse. And as usual, we look forward to a really interesting afternoon. So, welcome, everyone. Thank you for joining. Uh, and I don't think, Jackie, you need any sort of introduction. But so I'm going to hand it over to you. I presume we'll have a break at about midway. Are we
Yes.
talking about 3:30?
Yeah, that's right. 3:30, yeah.
Okay, so Jackie, now enthrall us with case law and updates for 2024. Thank you.
Sure. Thank you. Thank you, Stan and Danny, and good afternoon, everybody. It is a pleasure to be chatting to you once again. I can't believe we're already at the next webinar. It seems that these last few months have gone by so quickly. I trust that Danny is recording so that if anybody does need to access the recording, I'm sure it will be there. But yeah, so we're going to be covering today an update specifically focusing on case law and tax administration, TAA update. So case law, of course, we did cover cases up to the last webinar that I did with this group, and that was about 2 months ago. So the cases that are really important to talk about today, the big one is the coronation case, a constitutional court judgment. And then we'll also talk about the case of Poulter. But interesting that when we get to the draft legislation, there is an amendment already kind of speaking into the finding of the Poulter case, which was a Western Cape High Court case. In fact, Poulter involves the same people that SARS has had a long-running dispute over the years. And you may remember the young lady, Candice van der Merwe, who went over to the Seychelles some years ago and subsequently received a large sum of money paid into her account, supposedly for appreciation of her beauty. And SARS was seeking to attach that money, believing it was actually money of her father's, and they had a big tax claim against the father. And yeah, so that was the van der Merwe judgment, and she subsequently has got married, and so Poulter is her married name. and here she is back in court again. And this relates to her father wanting to represent her in the tax court and whether he could in fact represent her. But let me not get too far ahead of myself. We'll get onto that judgment just now. And then, of course, talking about tax administration, I think the main thing to look at is the recent legislative changes. So we had the draft legislation that was recently released for comment. Comment has now closed. I just saw that SAICA submitted quite detailed comment on this draft legislation. We'll be, of course, just focusing on the administrative amendments. So Tax Administration Laws Amendment Bill. But just to note that they did also release the Draft Revenue Laws Amendment Bill and the Draft Taxation Laws Amendment Bill. Okay, so we'll dig into these administrative changes, the proposed changes, which links on to what was announced in the budget speech that was presented in February of this year. All right, so we'll focus on that, and then we'll also look at recent SARS documents. So there's a couple of interpretation notes, binding general rulings, and things around filing season that would be interesting to have a look at. So yeah, so that's the outline of what we're going to be covering today. So we will go through until 3:30, and then we'll take a 15-minute break and then resume at 4:45, and then go through until for about just before 5 o'clock. Okay, so we'll be done certainly by 5 o'clock. All right, so let's go straight into it. And I think a really important judgment, this judgment of coronation, I think, well, what of course is particularly important is the fact that it's a constitutional court judgment. I think this now brings the tally to about 5, maybe 6 tax disputes that have gone through to the Constitutional Court. And it does seem to be a trend. In fact, we've got a few cases that are currently before the Constitutional Court or have just recently been heard, and we are waiting for the judgments to be handed down. That includes a Thistle Trust judgment, and it also includes various disputes which have been combined together relating to the Section 105 process, where one can look at getting a High Court review and kind of bypassing the normal dispute resolution process. So those judgments we are still waiting for from the Constitutional Court. And yeah, so this one, of course, just being a straight down the line income tax matter dealing with Section 9D, controlled foreign companies. I think what is also really significant about this judgment is the sheer magnitude of the amount of money involved. So as we go through and we have a look at the dispute, but the dispute really resulted in an amount of tax hovering around the 1 billion rand mark. Well, that was tax plus penalties and interest that SARS alleged was owing to them. And of course, the taxpayer argued against that, and that's what resulted in this appeal through to the Constitutional Court. But I think one also, you know, when you look at the commercial implications of these types of disputes, and I just think there's probably a number of corporates tied up with disputes with SARS, and the sort of damage it does, especially when you're talking about a listed company, because although this is a PTY, but it's wholly owned by Coronation Limited, which is a Coronation Fund Managers Limited, which is a listed company, right? Now, with this dispute that went on from the tax court, you'll see here in 2021, then it went through to the SCA, that judgment handed down, which went against the taxpayer. So initially the tax court found in favor of the taxpayer. Then the judgment at the SCA went against the taxpayer. Let me just see what's in the chat. Okay, it's just Danny chatting to someone. All right. So after this judgment went against the taxpayer in February 2023, there was quite a significant fall in the Coronation share price. So it was at a high of 55 Rand 41 in May 2021. So from 55 Rand down to 29 Rand on the 19th of May 2023. So that's after this judgment had been publicized. Well, interestingly enough, and I think we all know that Coronation was successful in this Constitutional Court judgment. I'm just going to go and talk about all the detail around what the case actually involved. But now that they've had this success and this potential tax liability has fallen away, I think you might have seen that in the last week or so, Coronation announced a special dividend to its shareholders. And I think it's 1.05 Rand per share. Don't quote me on that, but special dividend that's going to the shareholders. because they've now got, well, they don't have to have this impairment, this possible loss of profits that would otherwise have been there. Although their share price still hasn't bounced back to the original levels, it's trading at about 36, 37 Rand now. But certainly it is up from the low that it fell to following the publication of this judgment. So I just think it's important also just to think about the fact that we, although we talk about the tax dispute, we all know that there are broader issues here. And of course, when you're talking about a large listed company being involved in this level of a dispute with SARS, this amount of money, possible tax liability of around 1 billion Rand, yeah, it does have significant commercial implications as well. All right, so as I say, the case revolved around the question of Section 9D of the Income Tax Act, which is the controlled foreign company provision. And of course, the controlled foreign company provision, basically in a very simple way, it refers to where you've got a foreign company, more than 50% of the shares or voting rights are held collectively by South African residents. And then the implication of that is that if you take one of the residents who's a shareholder, in this case, this company was the sole shareholder, but they would then have to include in their taxable income. So the resident would have to include in their taxable income the net income of the foreign company, the controlled foreign company. So you would have to actually go to the controlled foreign company, do a tax calculation as if that controlled foreign company was a resident, work out then what we refer to as net income, and that net income then has to be included in the taxable income of the South African shareholder. All right, so that is the requirement of Section 9D, but there is an exemption. And there's a few exemptions. The one particular one that's under scrutiny in this dispute is the first exemption, which is whether there's a foreign business establishment. All right, so if there's sufficient economic presence of this foreign company in the foreign jurisdiction, then we would not tax those profits in South Africa. But if there's no foreign business establishment, and if none of the other exemptions apply, then indeed we would have to tax those profits in the hands of the shareholder in South Africa. All right, so Coronation Investment Management SA Pty Limited held the shares in the foreign company, and there was no dispute that the foreign company was a controlled foreign company, as defined in Section 9D, but the dispute was around whether the net income was derived from a foreign business establishment of the controlled foreign company. So that's really the focus issue here. Now, Coronation had not applied Section 9D because they were of the view that the foreign business establishment exemption applied. And so as far as SARS was concerned, Coronation had then understated their taxable income, and they'd also understated or underestimated their taxable income for provisional tax purposes. So there were then those other penalties that came into play as well, the understatement penalty and the underestimate penalty for provisional tax. All right, so all of these added together, and then plus interest, of course, to arrive at this total tax liability of close to 1 billion Rand. So I think it was 700 million Rand of the actual tax, and then there was interest of 200 million, and then there were penalties, but fortunately for the taxpayer, the penalties were waived at the SCA level. So going forward to the Constitutional Court, what remained was the tax liability and interest on that tax liability. But of course, considering that this related to the 2012 year of assessment, and we're now sitting in 2024, you can appreciate that the interest liability was very substantial. Okay, and that's how it ended up at around 200 million Rand. Okay, so it involved two penalties, the provisional tax penalty, underestimate penalty under paragraph 20, the understatement penalty in terms of the Tax Administration Act, and then, of course, this question of Section 9D and whether there was a foreign business establishment. So just to look at the ownership structure. So the controlled foreign company was this one down here, CGFM. That was a company incorporated in Ireland, and all the shares were held by CIMSA, which is the taxpayer, the appellant in this particular case, all right, Coronation Investment Management SA. So CIMSA owned 100% of the shares in Coronation Ireland. Shall we say it's Coronation Fund Managers in Ireland. And so that became a controlled foreign company. CIMSA also held shares, and it was a little more complex, but just to simplify the holdings, they held shares in a South African company and a UK company. And the shares in CIMSA were held by Coronation Fund Limited, and that, of course, is the listed company that I was talking about just now, the company that's listed on the JSE. But they're not the ones that are the focus of the case. The one that is the focus of the case is CIMSA over here. So the question is whether the profits derived by CGFM in Ireland would have to be taxed in the hands of CIMSA in South Africa under Section 9D. Now, it's entirely possible and very possible, although Ireland is a bit of a tax haven, but if we looked at the profits of CGFM derived from a business establishment in Ireland, yeah, they would be taxable in Ireland. If they ended up having to be taxed in South Africa under Section 9D, then what CIMSA would do is they would then look at getting a 6-quart rebate for the taxes paid in Ireland. All right. But so there would be some tax relief as far as that's concerned in terms of the foreign tax credit. But just looking at CGFM, as I say, the key question is whether it was deriving its income from a foreign business establishment. If the answer to that is yes, then Section 9D would not apply, and CIMSA would not have to include that taxable income in their taxable income. But if the answer is no, then indeed Section 9D would apply. Now, SARS wanted to include that net income of the Irish company, CGFM, on the basis that it was a controlled foreign company and that the foreign business establishment exemption did not apply, and therefore Section 9D did have to be applied in this case. Whereas CIMSA said that, in fact, it was a foreign business establishment, therefore they were eligible for the exemption under Section 9D, 9B. And SARS was arguing that this exemption did not apply because although CGFM, the Irish company over here, was carrying on a business, had an office, had staff, had structure, and all the rest of it in Ireland, but they said some of the core functions had been outsourced. And what had actually happened, in fact, is that some of the functions had indeed been outsourced to these other companies over here. So some of the fund management, not the fund management, the investment management and some of the marketing activities had been outsourced to CAM and SIL, which were South African and UK companies. Now, SARS was looking at a proviso in the exemption, which said, in essence, that one could outsource, but then only to other group companies that were in the same tax jurisdiction. In this case, these functions had been outsourced to other companies in other tax jurisdictions. And that seems to be a large part of the reason why SARS said that the foreign business establishment exemption did not apply. And because they said that CIMSA had then understated their taxable income, they imposed this understatement penalty. And as I mentioned, they also imposed the underestimate penalty for provisional tax purposes. Now, as I alluded to in the introduction, when this matter initially went to the tax court in Cape Town, that tax court found in favor of CIMSA, and everything looked rosy at that stage. But then SARS took the matter on appeal to the SCA. When the matter went on appeal to the SCA, the taxpayer took this matter, of course, on the understatement penalty on appeal as well, arguing that they were not liable for the understatement penalty. Now, SARS had imposed a 10% penalty on the basis that it is a substantial understatement. I mean, as the financial impact I've already explained. And so that's why the 10% penalty applied. But CIMSA argued that this penalty should fall away because they had relied on a tax opinion procured from a leading tax expert, but they did not disclose the contents of the opinion, nor make the opinion available to SARS. And I mean, that's perfectly acceptable. That is privileged documentation. They're certainly under no compulsion to disclose that to SARS. But they said they did have a tax opinion, they had relied on it, and therefore they had operated in good faith. And the fact that they ended up with a difference in interpretation from what SARS saw didn't detract from that. But SARS inferred that the non-disclosure indicated that there was some mala fides here. They said that it was very likely the tax opinion may not have supported CIMSA's claim for the exemption, and that there was a deliberate and conscious decision to exclude the net income. And therefore, it was not a bona fide inadvertent error. So remember that with an understatement penalty, SARS, in fact, the Tax Administration Act says that SARS must apply an understatement penalty where there is an understatement that has caused prejudice to SARS. So there's an understatement or there's an incorrect statement on a return, etc., that has caused prejudice to SARS, except where that understatement has arisen from a bona fide inadvertent error. And so where there's a bona fide inadvertent error that has given rise to this understatement of taxable income, then the understatement penalty cannot apply. That's why CIMSA was arguing that indeed there was a bona fide inadvertent error, and the evidence of that was that they had relied on this tax opinion. All right, so SARS was saying that there was mala fides because they hadn't seen the tax opinion, but the SCA held in this aspect, they found in favor of the taxpayer, that in fact the taxpayer was not obliged to disclose the tax opinion to SARS, and not making the opinion available to SARS was not sufficient to attribute mala fides on the part of CIMSA. All right, so on that basis, so what the SCA did, they agreed with the taxpayer that there was an understatement that arose from a bona fide inadvertent error because the taxpayer had relied on this tax opinion from a tax expert. That also assisted the taxpayer's case as far as the underestimate penalty on the provisional tax was concerned, right? In terms of the waiver provisions in the fourth schedule. So both the understatement penalty and the underestimate penalty fell away at the level of the SCA judgment. But we still were left with the actual amount of tax that was in dispute. And as I say, this comes down to Section 9D. So if we look at the wording of Section 9D, it tells us, deals with the net income of controlled foreign companies, and a controlled foreign company, as I mentioned earlier, more than 50% of the total participation rights, etc., or voting rights are held by one or more residents. So it's a foreign company, more than 50% held by residents. Can be one resident or a collection of residents, but if more than 50% is held by residents, that foreign company becomes a controlled foreign company, which may result in the application of Section 9D. But of course, as I mentioned, there are also certain exemptions that one must look at in Section 9D9. And that tells us that these exemptions apply in a range of scenarios. The one particular one in Section 9D9B is that where you've got the net income of the controlled foreign company is attributable to a foreign business establishment of that controlled foreign company. Okay, so there's no doubt that CGFM, the Irish company, it was a foreign company held 100% by a South African company, so it was a controlled foreign company, no argument about that. But the argument was whether the net income of that controlled foreign company was derived or attributable to any foreign business establishment. Now, what makes a foreign business establishment? Well, that also is defined in Section 9D, and it tells us that a foreign business establishment in relation to a CFC means the following. So it talks about a fixed place of business located in a country outside South Africa, used for carrying on the business of the CFC. All right, so we're talking about a fixed place of business that's going to be used to carry on the business of that foreign company, the controlled foreign company, for a period of not less than 1 year. So there must be some durability of that fixed place of business. And then it goes into a number of considerations. All right, so it's looking at all of these different things. And it's looking at the place where the business is conducted. So it has to be in an office, shop, factories, warehouses, or other structures. So there's a structure requirement. Remember, we're talking about a fixed place of business. But now what gives this fixed place of business economic substance, if you like? All right. So there must be a structure to the business. You don't have to own it, but you must be conducting your business from there. It must be suitably staffed with on-site managerial and operational employees who conduct the primary operations of that business. Okay, so you can't just have some random employee sitting there who's just going to sort of log in every day, check a few emails, and then go home again. There must be some people who actually conduct the primary operations. And that brings us to some of the key issues in this case. It says the primary operations of that business. And so we have to say, well, what is the business of CGFM and what are the primary operations? And those are the two key questions that we'll come to in the judgment. As we go through the other sort of substance aspects of this fixed place of business, it has to be suitably equipped for conducting the primary operations of that business. So again, the primary operations and what is the business. But notice here, this is talking about how it is equipped. So we've had structure, staff, equipment, and then facilities for conducting the primary operation of that business. And the fixed place of business is located outside the Republic solely or mainly for a purpose other than avoiding tax, effectively. Okay, so when we look at this economic substance, we have to be operating outside the country from a fixed place of business, operating for at least a year, all right, not less than a year, and you have to have adequate staff, adequate structure, an adequate structure that you're operating from, and adequately equipped. All right. So SARS was basically saying, well, in this particular case, and what I haven't shown you here is the proviso, because it's just going to go on for too long. But there's a proviso to this aspect of this definition, which basically says that if you're outsourcing, you can outsource, and so there can be another company that is providing this substance, if you like, as long as it's in the same jurisdiction and it's part of the same group of companies as your the main focus company that you are looking at. Now, the judgment looked here, they said the location of the primary operations referred to in these subparagraphs 2 to 4 was pivotal in determining whether there was a foreign business establishment. And so it was imperative to determine whether the primary operations had been outsourced, because if those primary operations had been outsourced, that might indicate that the 9D, 9B exemption did not apply. All right, so you really need to then look at what is the business of this Irish company and what are the primary operations, okay? Because your primary operations need to be conducted in Ireland. If those primary operations are conducted somewhere else, then you can't say that you got a foreign business establishment in Ireland because your primary operations are not based there. You don't have that economic substance there. Now, in the SCA, they basically said that all the core and non-core functions had been outsourced. In reality, all the non-core functions had been outsourced. So the actual investment trading activities had been outsourced. Certain administration and custodial functions, marketing had been outsourced, as I indicated to you on that diagram just now. And they'd been outsourced to these other group companies, but they were situated in South Africa and the UK, right, outside. But what about the core functions? And so this really is what we're going to be looking at in the Constitutional Court judgment, is they were focusing on the core functions. In the SCA judgment, they said that the primary business function or the core function was investment management. And because that investment management was outsourced outside Ireland, there was no... They did not meet the requirement of having a foreign business establishment, and they couldn't qualify for the foreign business establishment exemption. But then the thing is with the SCA is that they took the approach of saying, well, although you've got this business carrying on fund management and investment management in Ireland, they sort of focused on the investment management side of it. And they said, that's your core business and that's what's been outsourced to your UK and SA companies. Therefore, you don't have a foreign business establishment. But in the Constitutional Court, they took a much more business-like view. In fact, they referred to that approach of the SCA as taking on a bit of a notional business approach. What could you do? But in essence, you need to look at what is actually happening with this taxpayer. What is the taxpayer's actual business? And what are the taxpayer's primary operations. Okay, so although the SCA reversed the tax court's decision, the matter then went on appeal to the Constitutional Court. Now, as I said, the taxpayer was only appealing the issue of the application of Section 9D and whether the foreign business establishment exemption applied. But SARS did bring a cross appeal on the penalties, because remember that the SCA had found in favor of the taxpayer around the penalties. SARS wasn't happy with that. But the taxpayer's appeal really was focusing on this foreign business establishment question. And in going to the Constitutional Court, of course, they're not going to just readily accept any tax dispute that comes their way. They have to evaluate whether it has jurisdiction in the Constitutional Court. In this particular case, as we've seen with the other Constitutional Court judgments dealing with tax, the leave to appeal was granted because the appeal raises arguable points of law of general public importance. So this aspect of law, it's looking at the interpretation of Section 9D and the interpretation of this foreign business establishment. What constitutes a foreign business establishment? How do we interpret that, the wording of that provision? And so it's a point of law as opposed to a point of fact, a dispute on the facts. And it certainly is of general public importance because we literally have multitudes of foreign companies owned by South African residents. So I think if you add up how many controlled foreign companies there are in existence, certainly I think there, one could say there are many, many out there. And so many of them are very substantial in terms of the size economically. And so it certainly does have general public importance to know. And we all know this because of the shockwaves that came out with the publication of the SCA judgment in February 2023 and the knock-on effect. And everybody waiting. SARS immediately announced they were going to amend the legislation to bring in the SCA judgment. And there was a lot of fear and trepidation amongst the international and multinational business community. So it certainly does have general public importance. But the main issue is whether the CFC's net income should be included in the income of the South African parent company under Section 9D, or whether the foreign business establishment exemption applied. So the Constitutional Court, the findings were as follows. So they found that in fact, the Irish company did have a foreign business establishment and that the net income derived by CGFM was attributable to the foreign business establishment because their business model involved delegating investment management activities it was not licensed to perform. You see, when CGFM was established in Ireland, they were established because there was a need for the management of certain funds, collective funds in Ireland. And of course, just as we see here, that we see that banking and investment activities are licensed and have to be accredited and so on. And the same applies in Ireland. In fact, one of the reasons CGFM was established there was because of the very strong regulatory environment in Ireland. And as part of that, there's licensing conditions. And CGFM was licensed to perform fund management activities, but the actual investment management that was done had to be done by separate entities. So that was part of the licensing agreement. They were not licensed to perform those activities. All right, so that's the reality of it. You can say that you should be doing everything in Ireland, but the reality was they were not licensed to perform those particular functions. And therefore they outsourced. And that outsourcing was very much in line with other similar businesses operating not only in Ireland, but even in South Africa. Similar businesses operate in a similar way, where they outsource some of the functions. And I've lost my slide. Yeah, there we go. Okay, so CGFM's net income, the Constitutional Court said should not be included in their taxable income because the foreign business establishment exemption applied. And the Constitutional Court took a very strong line against the SCA findings. They criticized the SCA's outcome and they criticized the so-called notional business approach that I alluded to earlier, where the SCA was really saying, well, you should operate in such and such a way. But the reality was that that is not how that Irish business was operating, nor in reality was it how it was licensed to operate. And so it seemed that they took a more notional business approach as opposed to looking at the reality of the situation. And so their notional business approach considered potential activities rather than actual operations. The Constitutional Court emphasized the importance of considering the company's business model and the licensing conditions. And they held that the Irish company's operations from its Dublin office did indeed meet the criteria for having economic substance, and therefore they did have a fixed place of business, and the income was attributable to that fixed place of business. And so the Constitutional Court upheld Simpson's appeal. They set aside the SCA order and they found in favor of Simpson. And then, of course, SARS cross appeal on the penalties fell away because there was no longer any tax liability as a result of the success of the appeal by the taxpayer. All right, so the Constitutional Court did not address the issues around the penalties because they became a moot point. So the Constitutional Court also ordered SARS to pay the costs at the Constitutional Court level, which is interesting, including the costs of two counsel. And when you read the finding and the judgment of the Constitutional Court, it really is quite scathing insofar as the finding of the Supreme Court of Appeal was concerned. And I think what is interesting is that it kind of highlights some of the problems that we've seen in recent SCA decisions, that the SCA seems to often side with SARS for some reason. And that's also why we're seeing quite a number of these tax cases having to go through to the Constitutional Court, because these are judgments that are coming out at SCA level, which used to be the highest decision, right? But many times there's not sufficient legal basis or substance to these decisions from the SCA. And that's certainly what we saw coming through here. And so the Constitutional Court was scathing. Yeah, there's no doubt about it. Certainly very critical of the finding of the SCA and the approach that had been taken by the SCA. So a good outcome for the taxpayer. And I think as far as all of the other companies, and yeah, not just companies, of course, but all people with foreign subsidiaries, it at least gives us a reasonable amount of certainty, and it gives us some direction as to what not to do. Okay, don't take this notional business approach. Look at the actual approach. Look at the actual business carried on by the taxpayer. Why is that business established there? What structure does the business have there? And as long as you have sufficient economic substance in that foreign jurisdiction, then the income should not be subject to Section 9D. Now, as I said initially at the time of the SCA judgment and the budget speech that was presented, soon after that, SARS very quickly said they're going to amend Section 9D and they're going to import all the aspects of that SCA judgment. Well, that certainly is not going to happen now, because that SCA judgment has received such severe criticism from the Constitutional Court. If anything, we may need more clarity in terms of this issue around outsourcing. So after the judgment of the SCA, the fear was that, is it going to be that you cannot outsource any of your business in this foreign jurisdiction? Certainly not to companies in other jurisdictions. And what we're seeing in terms of this Constitutional Court finding is that outsourcing doesn't necessarily preclude the access to the foreign business establishment exemption. So outsourcing in itself is not ruled out. But I think the key thing that you must be careful of when you are outsourcing some of your activities from your business in that foreign jurisdiction is that you must not be outsourcing your primary functions. All right. So going back to what I was saying earlier in terms of the wording of this definition of foreign business establishment, you need to be having an operation in the foreign jurisdiction that is supporting the primary operations of that business. And so that's what you can't be outsourcing. That must be done in the foreign jurisdiction. So if you have a company operating in a foreign jurisdiction and then you outsource your primary functions back to an administrative company in South Africa, that's where you could have a problem. You wouldn't be able to access this foreign business establishment exemption, and then Section 9D in all likelihood will apply. So the key thing is be careful about what you do outsource, and don't outsource your primary operations, because that needs to be done in that foreign jurisdiction. All right, so quite an interesting outcome as far as that Constitutional Court decision is concerned, and I see that little chat has just popped up. Just see, yeah, okay, so yes, Danny has asked if the chat can go into the Q&A. Yes, and if you could just do that, that'd be great. Thank you. Yeah, so if you do have any questions, pop them into the chat box, and then that would be the best way to get your question attended to. Okay, all right, let's go on then to the Poulter case. And as I say, Poulter used to be Ms. van der Merwe, and she's now Mrs. or Ms. Poulter. And basically, there was an issue here. As I say, her and her father, Gary van der Merwe, have had ongoing disputes with SARS going back many, many years. And in this particular case, it dealt with an assessment for the 2018 tax year. And we're not going to get into the nitty-gritty of the actual dispute, but the issue really that we need to look at with the Poulter case is who can represent a taxpayer in the tax court. So the father, Gary van der Merwe, wanted to represent his daughter in the tax court, and SARS was saying, no, you can't do that because you're not a registered legal practitioner, and only a legal practitioner can represent somebody in a court of law. So then that led us to the question of, well, what is the tax court actually? Is the tax court a court of law, or is it an administrative tribunal? And the judgment goes into quite a lot of discussion around this. It all, of course, stems from Section 116 of the Tax Administration Act, because the tax court is established in terms of that particular provision. And that says as follows. It says the president may proclaim in the Gazette a tax court or additional tax courts for areas that he thinks fit, and may abolish an existing tax court, and a tax court is a court of record. So that's pretty much all it says. And then, of course, we know it goes on to talk about the president of the tax court and how the tax court operates and all that sort of thing. But the question is, what is the status of the tax court? Is it an actual court of law, or is it an administrative tribunal? And in this judgment, the conclusion was, having assessed all the characteristics of the tax court in light of the jurisprudence, the court concluded that the tax court actually is an administrative tribunal and not an actual court of law. So when we look at a court of law as established under the Constitution, that talks about obviously your Constitutional Court, your SCA, and your High Court. But the tax court is not an actual court of law in terms of the constitutional concept of a court of law. So if the tax court is not an actual court of law under the Constitution, it's an administrative tribunal, well, can a layperson represent a taxpayer? Now, we always used to understand absolutely, and that was really because the Tax Administration Act, and of course this draws on from the previous legislation that applied before the Tax Administration Act even came in, is that we had this provision which carried into Section 125(2) of the Tax Administration Act, and it said the appellant or the appellant's representative may appear at the hearing of an appeal in support of the appeal. And the accepted interpretation was that anybody can represent a taxpayer in the tax court. All right, but this provision was then deleted in 2017, and it did lead to some confusion. The court came to the conclusion, though, that the deletion did not make a practical difference. And you'll see that's outlined in the judgment if you want to go and have a look at it. And so the conclusion was that at the end of the day, a layperson can represent a taxpayer in proceedings before the tax court. But what we will see is that this is now being clarified in the draft Tax Administration Laws Amendment Bill. So in this case, the tax court had erred in denying the father the right to represent, and so the taxpayer's appeal was upheld and referred for another hearing. Okay, so yeah, you'll see this coming through in the draft amendments that we'll talk about just now. Now, it brings me on to leading into these draft amendments. So The key proposals, and as I mentioned earlier, we had released right at the beginning of August, the Draft Revenue Laws Amendment Bill, the Draft Taxation Laws Amendment Bill, and the Draft Tax Administration Laws Amendment Bill. Now, we're not going to talk about all of the amendments today because the mandate for today is really looking at Case Law and Tax Administration Act update. So what we will be looking at today is just the administrative provisions in the draft bill. Okay, so when you look at these administrative provisions, they cut across different areas. Remember, it's not always just the Tax Administration Act, but it also looks at administrative provisions in the other acts. So we look at the VAT Act. We see some amendments coming through around importation of goods and imported services and the rules for imported electronic services. And then here we go with the taxpayers' representatives in the tax court, and that leads on from that Poulter judgment that we spoke about just now. And then we look at requests for relevant material, access to taxpayers' records, and this leads on from the Arena Holdings judgment, another constitutional court judgment that came through a year ago or so, and that, of course, harked back to Jacob Zuma's tax records, and we'll talk about that just now. But we see some amendments coming through in the legislation around that. And then clarifying provisions relating to auto assessments, and then reviewing dispute resolution proceedings, just reviewing some of the processes there. There's a number of amendments coming through in that regard. And then reviewing temporary debt write-off provisions and rules for appointing a public officer. We saw quite a lot of movement around this last year, and that was, of course, to strengthen our regulatory environment following the grey listing, the introduction of the grey listing of South Africa. And now these are additional rules. These really relate to your imported services, and especially your imported electronic services. So it's relating to people carrying on business outside South Africa and what the requirements are around public offices in that regard. Okay, so this really is speaking and linking very much to the imported services situation. Just take note that whenever we talk about these draft amendments in the Tax Administration Laws Amendment Bill, unless stated otherwise, the amendments will become effective on the date that this bill is promulgated. So it will then be an act, and when the act is promulgated. So, for example, last year's, the 2023 bills were promulgated sort of around about the 20th of December 2023. That was quite early. Often they are only promulgated in January of the following year. So in all likelihood, these amendments will become effective, either December this year, January next year, whenever this amendment is actually promulgated. So there's still quite a process that these draft bills have to go through. So they've been released for public comment. Public comment closed end of August. Now, SARS and National Treasury will give consideration, hopefully, to all the submissions that are made by whoever has made these submissions. And often the submissions are made by more than 100 different stakeholders. And that includes your professional bodies like SAICA, SAIPA, etc. And then you've also got your large firms. So you might have your big four firms making submission, you might have your law firms making submissions, and any other interested parties. So it just depends what the nature of the amendments are. All right, so that SARS and National Treasury will then consider all of these submissions that have been made, and they then have to draw up their response document, and they have to then revise the legislation where they consider it necessary to make the revisions. And then we get the final legislation that is normally, that's tabled at Parliament on the date of the medium-term budget speech, which is usually towards the end of October, like around about the 25th, 26th of October. So that's the kind of timeline that we're looking at this year. So these are still the draft amendments. It is possible that things will still change. So what we really need to be looking at is the final amendments that come through at the end of October, and those I will run through when we do our next tax update, which will be in November. That'll be our year-end update, and that's when I'll run through the final bills. Okay, and we'll do the final Taxation Laws Amendment Bill with all the detail in there, and then also the Tax Administration Laws Amendment Bill. and yeah, if there's any changes to what we're talking about today. Many of these things I don't see as being subject to any major change, but there might be some tweaking of wording here and there. But otherwise, I don't think, we'll sort of look at it more closely as we go through, but I don't anticipate any major changes from what I have on the screen as far as these provisions are concerned. Okay, there are some other proposals in the Taxation Laws Amendment Bill that I do think will have to be, seriously reconsidered. Okay, but as far as these particular amendments are concerned, so in terms of the VAT on imported services, now, if we think about VAT on imported services, so if you are a vendor, in fact, if you are any person in South Africa, and you import services, we have to raise output tax on your services that are imported other than where those services are used to make taxable supplies. So if you have a kind of a business-to-business imported service, so you're importing services in order to make taxable supplies here in South Africa, then you don't have to raise output tax on the imported service. But if you're importing services other than for making taxable supplies, then you have to raise output tax. Okay, and this links to the timing of the VAT on those imported services, and it comes through Section 14 of the VAT Act. Currently, your output tax has to be accounted for and it's payable by the recipient of the imported services within 30 days of the earlier of receipt of the invoice issued by the supplier or the recipient, or the time the recipient makes any payment. So the earlier of invoice or payment, but it's talking about 30 days currently. And the concern that has been raised is that that 30-day time frame is just too tight. It's impractical. It's impractical for people to comply with that. And the failure to pay that within that time frame results in the imposition of penalties and interest. And so the proposal is to extend the 30-day to 60 days. All right, so that looks fairly straightforward. I did see that in the SAICA submission that they've made to SARS and National Treasury, they have also pointed out that we count the days. So whether it's 30 days or 60 days, you're counting it effectively from the earlier of receipt of the invoice or payment. And the issue that when you're talking about international transactions and imported services, this receipt of the invoice and the payment that is made, you often have to go back to the date of the invoice, and then that can be quite difficult to do, because that the timing around receiving the invoice, making the payment, etc., they are suggesting that you should rather count the 60-day period from the date of payment, all right, rather than looking at the date of the invoice. Okay, so we'll see whether that flies, whether they accept that recommendation, but certainly what's in the Act or what's in the draft legislation is that we're going to push this 30-day period out to 60 days. Okay, and then what about overpayments of VAT? Now we're talking about the importation of goods and services. So remember that in terms of Section 7 of the VAT Act, apart from the VAT on imported services that I just spoke about, and I explained when that becomes relevant, but any person importing goods into South Africa. So imported services, it's only when you have an imbalance, so those services are imported other than for making taxable supplies, then you have to raise output tax. But importation of goods, any importation of goods into South Africa is going to carry not just customs duty, but also VAT on that importation. Now, what if you overpay the VAT on the importation of goods and services? So if you think about it, if you have to raise the output tax on the importation, you've got to pay that output tax before you can get the goods cleared out of the customs warehouse. And you would, if you're going to use those goods in order to make taxable supplies, you're going to get an input tax pretty much at the same time. So output tax, input tax, and off you go until you actually sell those goods. But what if you overpay on the importation of goods, so you pay too much VAT? Now, the point that's made in the explanatory memorandum, while the VAT Act, read with the Tax Administration Act, provides for a refund of an amount under an assessment of an amount erroneously paid, it does not adequately cater for a reduction in the amount of tax chargeable as a result of a subsequent event in respect of the importation of goods by persons who are not registered as vendors, or in respect of imported services where there's no assessment. So if you're a vendor, as I say, you're going to raise the output tax and claim the input tax. But if you're not a vendor and you've paid VAT when perhaps you don't need to pay VAT, then how do you get that VAT refunded? And that's really the question that is being addressed in this proposed amendment, is they're looking at trying to introduce a way of getting that overpayment of VAT refunded. So vendors are catered for, non-vendors are the ones who are at risk at this stage. So they want to introduce subparagraph P, which, and to section 16.3, so it'll be section 16.3P, will provide any amount of tax paid by a vendor in terms of this act in excess of the amount of tax that should properly have been paid. So if you're a vendor, you would claim that back as an input tax if you've done an overpayment, all right? So fair enough, that would just be another category of input tax. But for a non-vendor, they are proposing another consequential amendment to section 44 that will provide for VAT refunds for non-vendors. And there, the non-vendor would have to apply to SARS to get that VAT refunded to them. Okay, and that's really how that would work in terms of the overpayment of VAT. Okay, then we go to the imported electronic services. Now, imported electronic services was introduced into our VAT Act quite a number of years ago. You may recall that we had an extension to the definition of enterprise. And of course, what is the relevance of the definition of enterprise? If you have a person who is carrying on an enterprise in South Africa, that could cause that person to have to register as a vendor, right? So if you make supplies in the course of carrying on an enterprise that exceed a million rand a year, you would have to register as a vendor. Now, that definition of enterprise was extended, and I'm just scrolling through my legislation to give you the exact reference here. Just finding it here. For some reason, I'm not seeing it, but there was a new paragraph that was added into the definition of enterprise. Yes, here we go. That talks about what is an enterprise. And in the definition of enterprise in Section 1 of the VAT Act, that's been extended to also include the supply of electronic services by a person from a place in an export country, basically to a resident. Okay, so that was introduced back in 2013. So for the last 10 years, we've had these rules that a supplier of imported electronic services. So electronic services, something other than your tangible services. So that could be things like on Apple Music, your online videos, gaming, that sort of thing. So imported electronic services supplied to a resident. And what would indicate that those services are being supplied to a resident is that the person would actually be a resident, or they would have a South African bank account, or they have an address in South Africa. All right, that would indicate that you got imported electronic services provided to a resident. And where that is the situation, the non-resident would have to perform all the functions of a vendor, just like any other vendor providing services to a resident. And so that would require your non-resident supplier to actually register as a vendor and to raise VAT, to raise output tax on these suppliers, and to issue tax invoices and so on. And so I'm quite sure that if you have a look at the last invoice you got from Apple, for argument's sake, for your subscription, you'll see that they charge you VAT because they've gone and registered as a vendor, and they charge VAT on their supplies to South African resident users. Okay, now when this all happened 10 years ago, that they introduced this regime for imported electronic services, that applies regardless of whether the person using those services is going to use them for the purpose of making taxable supplies or not. Think about what I said earlier about imported services. I said that you have to raise output tax on imported services only if you are going to use those imported services other than for making taxable supplies. So if you're somebody who's going to use those imported services to make taxable supplies, you wouldn't raise output tax. So that business to business transaction is unaffected. But where you've got a business to private transaction, when I say private, a non-vendor, that would be affected. Now here with imported electronic services, they didn't make that same distinction. They just basically said any supply from a non-vendor to a South African resident, if it's imported electronic services, it falls within the ambit of this legislation, and the supplier will have to register, etc., etc. They've now sort of relaxed a little bit on that, and they have said that they would, going forward, this is not going to apply on a business-to-business type of transaction. But what they've also said is that they're going to relax a little bit in terms of your non-resident vendors. So they are making some changes here to Section 1 and Section 23. And this is what they've said in the draft explanatory memorandum. They've said, due to the wide definition of enterprise in Section 1, so it applies business, non-business, etc., any non-resident vendors may be required to register as vendors, even if they have no physical presence in South Africa or they have a very limited presence for a short period. And it's now come to light, government has realized 10 years later that certain non-residents have difficulties appointing a representative vendor who resides in South Africa and difficulties opening a South African bank account. And those are typically requirements that you have to have in order to register as a vendor. So the scope of the registration requirement for foreign providers of imported services is also too broad, and they want to exclude your business-to-business supplies. Similar to what happens, as I explained, with your imported services, okay, that you exclude business-to-business. So the proposed amendment does a couple of different things. So on the one hand, it waives the requirement that a representative vendor of electronic supplies resides in South Africa while maintaining the exemption from opening a South African bank account. So they introduced this exemption from a South African bank account a little while ago, but they're now going to say that you don't have to actually be residing in South Africa. And they're also proposing to extend this concession to non-resident vendors in other specified circumstances. Okay. So what's coming through then is that they're going to add on Section 23(1)(a), and they're going to add this following proviso, that if a person is resident in a country that South Africa has a DTA with, paragraph B, that's in terms of Section 23 with the registration requirement, which requires that you must have a South African bank account, that particular paragraph will not apply. And it's not just with your imported electronic service providers. It's basically in any case of a company that is an external company that does not have a fixed or permanent place in the Republic. Also in the case of a natural person that is physically present for less than 6 out of any 12-month period, and for any person that's an enterprise solely as a result of paragraph B6 of the definition of enterprise. That's the one I read to you about that you have an enterprise only because you provide imported electronic services to South African residents. Okay, so in those circumstances, your external companies, your non-resident individuals who don't spend more than 6 out of 12 months in South Africa, and your imported electronic service providers, they don't have to have a South African bank account. All right, and then there's some of the other amendments, it just goes on too long to include them all. But yeah, quite a lot of other amendments coming through around imported electronic services and just taking a more practical stance as far as the providers of those services are concerned. Okay, then we get on to your representatives in the tax court, and leading on from the Poulter decision that I referred to earlier. So remember, they're looking at who can represent a taxpayer in the tax court. Given that in the Poulter judgment, they came to the conclusion that a tax court is an administrative tribunal, it's not an actual court of law. And so you should be able to be represented by a lay person. So now we're seeing this being brought into the Tax Administration Act. Now, currently, Section 12 of the Tax Administration Act says as follows. It says, and let's just have a look at these two paragraphs. The one says, despite any law to the contrary, a senior SARS official may, on behalf of SARS or the commissioner, in proceedings referred to in a tax act, appear ex parte in a judge's chambers, in the tax court, or in a high court. All right, so there's 3 scenarios: in a judge's chambers, in a tax court or in a high court. So we've got a senior SARS official may represent SARS or the commissioner in any of those three scenarios. And then in subsection 2, it says a senior SARS official may appear in the tax court or a high court only if the person is a legal practitioner, duly admitted and enrolled under the Legal Practice Act. So that's where you've got a tax court or a high court. Now, and that refers, of course, to the SARS representative. It doesn't say anything about the taxpayer's representative. But now in the case of Polter, we've seen the confirmation that a taxpayer should be able to be represented by a lay person. And so how do we bring this into Section 12? Well, SARS, apart from bringing in that aspect to Section 12, you'll see that they are also taking this opportunity to make certain other amendments to Section 12. And so, yeah, we'll go through all of the different aspects that are coming through in the proposal. So the amendments are needed to clarify who can represent SARS, okay, because we have that in there, but they want to clarify that further, and also around costs. And that's going to be quite an interesting thing that you'll see. I'll talk about that as we go through the proposed amendments. So they need to elaborate on the wording to deal with the SARS representatives and who can represent a taxpayer. So let's have a look at these various amendments. So currently, I showed you Section 12.1, which currently says that, you know, your SARS official can represent in the judges' chambers, the tax court, or the high court. And now they're extending that to say, or any other court recognized in terms of the Constitution. Now, I mentioned earlier that the Constitution doesn't recognize the tax court as a court of law, but that is specifically mentioned there, right? As is the High Court. The other courts recognized would be your Supreme Court of Appeal and the Constitutional Court. Okay, so those are recognized in terms of Section 166. So that would enable a senior SARS official to represent SARS in the SCA and Constitutional Court, in addition to what's currently allowed, which is the tax court and the High Court, and also the judges' chambers. Okay, so the judges' chamber is still there, tax court is still there, high court is still there, but they're adding on this aspect of any other court. Section 12.2, and that previously stated as follows, apart from what's underlined over here. And so they're saying a senior SARS official may only appear as provided if the person is a legal practitioner, and it's going as provided under subsection 1. So it's pointing to all of that. Now, it's interesting. So it would say to represent in any of those situations, the senior SARS official, the SARS representative has to be the senior SARS official. And he must be a legal practitioner duly admitted and enrolled under the Legal Practice Act. So that's a requirement as far as the SARS official is concerned. But when we get onto the taxpayer, who represents the taxpayer, in the tax court, so here we see the new provision coming in, Section 12.3. Any natural person may appear on behalf of the taxpayer in the tax court if, oh, here we go. Okay, so here's the complication. If the president of the tax court is satisfied that the person is a fit and proper person to appear on the taxpayer's behalf. Oh, okay. Well, up until that point, it was all looking pretty straightforward. But how do you determine that the person is a fit and proper person? I mean, they might be dressed in a tie and suit, or, you know, ladies, high heels or whatever. But how do you know they're a fit and proper person to represent the taxpayer? Well, that wording is actually taken from this Legal Practice Act that we referred to earlier that binds the SARS official. But how do we apply that in this scenario where we're saying the person does not have to be a legal practitioner in terms of the Legal Practice Act? Okay, so they don't have to be fit and proper from a legal perspective. And so this additional requirement could prove to be a little bit difficult to apply. So there has been a question that maybe they should just leave this out or give clarity. How do you decide if a person is a fit and proper person to appear on the taxpayer's behalf? Surely the taxpayer is allowed to choose whoever they choose to represent them in the tax court. So that looks as if they're going to have to just tidy that up a bit, or issue or clarify in the explanatory memorandum, perhaps, what are the criteria that would meet the fit and proper requirement over here. Okay. Then they're going to also add on subsection 12.4, which says, and here we go with the costs, 12.4 and 12.5. It says where the senior SARS official has represented SARS, okay, Fees and costs may be taxed and recovered in the same manner as if such functions had been performed by a legal practitioner in private practice. So when the court awards costs, right, if they award costs in favor of SARS, and SARS is represented by one of their own employees, what they're saying here is that the cost that should be recoverable is not the cost, not that employee's salary, but actually whatever fees would have been charged by a legal practitioner in private practice. It's a bit of a notional number that they want to put in here. Now, that has been criticized quite severely. So it remains to be seen whether they keep that in the legislation. It seems a bit cheeky if the employee only cost them X rand per hour, that they're now wanting the court to award them costs at X times 10 rand per hour, or whatever the case might be. So it remains to be seen if that part will actually fly. In subsection 5, any costs awarded by a court must be determined in accordance with the fees prescribed by the rules of the court, and in the case of the tax court, the rules of the High Court. Okay, well, yeah, it just depends, because if you're represented by your employee rather, surely it's their costs that you're looking at. You can't start expecting the court to pay you over and above and pay you in court of the tariffs of the court. Well, yeah, we'll have to see what happens as far as that amendment is concerned. All right, so quite interesting that all these additional amendments to Section 12 prompted all by this question of who can represent a taxpayer in the tax court. Then the next amendment or proposed amendment that's coming through, and this is in terms of Section 47 of the Tax Administration Act, which deals with requests for relevant material. Now, Section 47 currently provides as follows. So it says that a senior SARS official may by notice require a person, whether or not chargeable to tax, or an employee of the person, or a person who holds an office, to attend in person at the time and place designated in the notice for the purpose of being interviewed by a SARS official concerning the tax affairs, if the interview is intended to clarify issues of concern to SARS, to render further verification or audit unnecessary, or to expedite a current verification or audit, and is not for the purpose of criminal investigation. So this is looking at where a person is called to come in for an interview with SARS. Okay, so they literally have to sit and have a face-to-face discussion with this senior SARS official, all right? Or the interview can be done just by a SARS official, but the senior SARS official would by notice require the person to present themselves for an interview, and looking at the scenario and the context in which an interview can be conducted. And now what they want to do is they want to expand this by adding in, you'll see A has two possibilities of when we might have an interview. So when it could render further verification or audit unnecessary, or to expedite a current verification or audit. And interesting, they use the word expedite there, all right? Now they want to add in subparagraph 3, which will also use the word expedite, that in this case to expedite the recovery of tax or an application for write-off or compromise of a tax debt. Okay, so quite what they're contemplating here. They haven't really said too explicitly. What they've just said is that this proposed amendment aims to expand the provision to include instances where a taxpayer is subject to recovery proceedings for an outstanding tax debt or has applied for debt relief, and to resolve or expedite these proceedings. So not necessarily just where there's an audit or verification, okay, but also where there's outstanding tax debt. Okay, so that's just another scenario where they could utilize the interview process. Now, I'm quite sure nobody really wants to go and be called for an interview with a SARS official, but yeah, just to be aware that they're going to expand the scope of when such interviews might actually be used. And then the next amendment, a really interesting one flowing from the Arena Holding judgment of 2023, also, as I mentioned earlier, from the Constitutional Court. And in that case, the Constitutional Court found that certain provisions were unconstitutional. Okay, and those particular provisions that they considered were Section 67 and 69 of the Tax Administration Act and Section 46 of the Promotion of Access to Information Act, or PAIA, P-A-I-A is what we often refer to that as. Now, in terms of the Tax Administration Act and PIA, all right, what we're looking at here is situations where you may be able to access a taxpayer's records. Now, obviously, in terms of the confidentiality provisions in the Tax Administration Act, it is very strong in terms of protecting the privacy of a taxpayer. And so we would expect that SARS may not divulge information around a taxpayer, etc., etc. But in Section 67 of the Tax Administration Act, it does say that in certain circumstances, a taxpayer's records may be shared. And Section 69 looks at some scenarios where the taxpayer's record might be shared. And that really, it's very limited, extremely limited. It talks about things like where the information might be necessary for a criminal investigation. So you might have the South African Police or the National Prosecuting Authority, or something like that. But it would be extremely controlled and very difficult to access the taxpayer's records. In terms of PIA even, it does allow, in terms of Section 46, it allows certain information, and I'm not talking about taxpayer information here, I'm talking about other information. Certain other information may be allowed to be accessed, but whereas other information might be allowed to be accessed, certainly not tax information. So it kind of excludes tax information. Now, in Arena Holdings, and as I say, this linked to actually an application by journalists who wanted to access Zuma's records, and that followed the book that was published around President's Keepers, which indicated, and they stated categorically in the book, that there was gross non-compliance by Zuma. And so the journalists wanted to get hold of Zuma's tax records to have a look at this and see what the non-compliance was. And so they applied under the Promotion of Access to Information Act to have sight of his records, and SARS emphatically refused access. And that's when they went on to the Constitutional Court to try and show that these provisions were unconstitutional. And the Constitutional Court did say that, yes, these provisions are unconstitutional because in extreme situations where it's in the public interest, access to certain tax records should be possible. Not to say that you can access anybody's tax records, but just in these extreme situations where it's in the interest of the public, that it should be allowed. And so they ordered that Parliament should amend the legislation. And in the meantime, the Constitutional Court ordered a read-in. And they said, in the meantime, this is how it's going to read. And they basically imposed their findings from the judgment to say, in these extreme situations, you should be able to access the records. I believe that in the meantime, Arena Holdings has gone back and tried again with SARS, and they've still been unsuccessful in obtaining the records that they seek. But nonetheless, these amendments that have been ordered, as it were, by the Constitutional Court have now been brought into the tax legislation. And so it does incorporate those amendments. Now, you'll see here, it also talks about amendments to the Customs and Excise Act. And although the Constitutional Court did not directly deal with the Customs and Excise Act, they have said in the explanatory memorandum that it makes sense to adjust those provisions as well, because they read in a very similar fashion to the other provisions that I have alluded to. Okay, so those amendments are coming in, and so it will read as follows. In terms of the Promotion of Access to Information Act, as I said, it currently says that you can access under various subsections. So it says, despite any other provision of this chapter, the information officer of a public body must grant a request for access to a record of the body contemplated in. And it spoke about all these different aspects, and now they've added in Section 35, which talks about tax information. So all of these refer to other types of information, and now they're adding in Section 35, which speaks to tax information in these very controlled circumstances. In terms of Section 67 of the Tax Administration Act, you'll see they're adding in wording here. So it's going to read, a person who receives information under one of these other provisions, sorry, I keep jumping here, must preserve the secrecy of the information and may only disclose the information to another person if the disclosure is necessary to perform the functions specified in those sections, unless the information has been received in terms of the Promotion of Access to Information Act, and that links to what I showed you up here. All right. So that's the only time that you can kind of cut through those confidentiality provisions, is when it's allowed under the Promotion of Access to Information Act in these very controlled and extreme circumstances. And Section 69(2) also will be amended by adding a subparagraph that will say where access has been granted for the disclosure of the information in terms of the Promotion of Access to Information Act. All right, so linking into this amendment to PIA as well. So yeah, so it will be brought into the tax legislation, but I mean, we have been operating as if it was in the tax legislation ever since this judgment, which was handed down early in 2023. So it's not really significantly changing anything. And I think it does still, it's not going to be easy to access someone's tax information. As I say, their Arena Holdings tried again with SARS and they've still been unsuccessful. So you know, this is something that you would have to fight for over quite an extended period of time, because obviously if you want to access the tax records of some politician, even if it's a very senior politician and you argue that it is in the public interest that you want to see these tax records, they also have a right to privacy, right? And so they're going to be fighting for their right to privacy as much as you're fighting for the right to access the records. And so this is likely to be a legal battle that's going to go back and forth for quite some time. So it's not going to be an easy fix to access these records. And I think that's quite right, because I'm sure, you know, if the shoe was on the other foot, you wouldn't want people easily accessing tax records of perhaps a client or a significant celebrity or something like that. Okay, so yeah, so we do need to have the protection of confidentiality. And so this is trying to protect confidentiality whilst also allowing some level of transparency when it is justified. Okay, and then on auto assessments, and then after this, I think we'll take a little break. So as far as auto assessments are concerned, you'll remember that we've had auto assessments with us for a few years now. They were introduced by SARS in 2020. And effectively what happens is that SARS raises an assessment on a taxpayer, right, based on the information that they have. And that's where they are pretty sure that they've got all the information they need around that taxpayer. So it's driven by what comes through the third-party disclosures on salaries, interest, medical aid, etc. And based on that information that SARS is getting from third parties, they would then raise an assessment called an auto assessment. Of course, the raising of an auto assessment does not do away with the person's obligation to submit a tax return unless they're 100% satisfied that that auto assessment is 100% correct. All right, but we'll come to the issue around the taxpayer's role with auto assessments a little bit later after the break when I talk about the filing season. But when we look at the actual legislative framework, remember that SARS is not allowed to do anything from an administrative perspective unless it is absolutely provided for by the legislation. And there's been a lot of criticism around what is the exact legislative provision that undergirds your auto assessment process. And there've been conflicting views because basically SARS is relying on Section 95, and they're saying auto assessments fall under my estimated assessment provisions of Section 95 of the Tax Administration Act. But if you think about the Section 95 of the Tax Administration Act, it was originally intended as a bit of a punitive provision. It was really intended as a provision to say, if you fail to submit a tax return, we can raise an estimated assessment on you. And now SARS is kind of turning that around, and they are raising this auto assessment and then saying, well, it's covered by my estimated assessment provisions. But is it really? Is it actually covered by that? Because there are many people, esteemed tax experts, who would say that Section 95 was never intended to cover something like auto assessment. So although, yes, we might say, well, we like auto assessments, they help a lot of people, or you don't like auto assessments, but that's not the point. The point is whether it is allowed and catered for in the legislation. All right, so now SARS, although they've been arguing vehemently that Section 95 does cover auto assessments, but now they're kind of changing their tune on this a little bit, because now they're actually amending the legislation to cater. And they're saying here, in terms of the memorandum on the objects, remember that's like the explanatory memorandum on the Tax Administration Laws Amendment Bill, they say the following. They say concerns have been raised that the current legislative framework only covers certain types of original assessments by implication. The proposed amendments aim to further clarify the legislative framework in order to address this concern, in particular in the context of auto assessment. So in other words, they want to clarify the legislative framework that pertains to auto assessments. And this is what they want to do. Oh, and they're not changing Section 95, they're changing Section 91. Section 91 is the provision that deals with original assessments. Remember, you've got different types of assessments. These are all covered in Chapter 8 of the Tax Administration Act, which starts with Section 91, original assessments. And Section 91, they're going to amend, and they're going to say, if a tax act or the commissioner requires a taxpayer to submit a return, or the taxpayer voluntarily submits a return, which does not incorporate a determination of tax liability, SARS must make an original assessment based on the return submitted by the taxpayer or other information. This is what they're relying on here, or other information available in respect of the taxpayer. Subsection 2 will say, if a tax act or the commissioner requires a taxpayer to submit a return, or they voluntarily submit, which incorporates a determination of a tax liability, the submission of the return is an original self-assessment of the tax liability. So it would seem that what they're wanting to do is to position your auto assessments within Section 91, which deals with your original assessments. Whether this wording is accurate and acceptable remains to be seen. There's still a bit of criticism around the wording here. But be that as it may, look, I think they're not going to do away with auto assessments. It's just a case of how they're going to amend the wording in the Tax Administration Act to properly reflect what SARS is already doing. Okay, but it kind of putting the cart before the horse, but be that as it may. They also want to add the following subsection. If a tax act or the commissioner does not require the taxpayer to submit a return, SARS may make an original assessment based on an estimate under Section 95. But this is coming in under Section 91. All right, so it's kind of saying, yes, you can raise an estimated assessment and as an original assessment. And that's effectively what your auto assessment is. Okay, so bringing it into Section 91 of the Tax Administration Act. Okay, so it's just on 3:30. So I think that's a good time to take a 15-minute break. So we'll see you back here at 15:45. See you just now. Okay, so it is 3:45, so let's carry on. Right. So we're now going to have a look at, we're continuing to look at the draft amendments affecting tax administration. And the next few amendments deal with the dispute resolution proceedings. Okay, so this is Chapter 9 of the Tax Administration Act. As you know, deals with your dispute resolution process. And remember that the dispute resolution process in the legislation has to be read together with the rules. And remember that the rules were updated in March 2023. Now, this is looking at 2 amendments to Section 104 and then also some amendments to Section 107 and 109. So when we look at Chapter 9, covering the dispute resolution process, it ranges all the way through from objections, appeals. It goes all the way through to ADR, to tax board, tax court, etc. Okay, and all the rules that cover all of those processes. So these amendments to Section 104. Now, just to put this in context, Section 104 is the kind of initiating provision in the dispute resolution process, talking about who can lodge an objection. And of course, the objection then is the starting point of the dispute. So in Section 104, it talks about a taxpayer who is aggrieved by an assessment made in respect of the taxpayer may object to the assessment. That's in Section 104.1. Section 104.2 talks about what kind of decisions can be objected to. So it talks about, because you got the assessment, all right, that we spoke in subsection 1. This talks to decisions of the commissioner in certain circumstances can be objected to. And one of these decisions that can be objected to is a decision under Section 104.4 not to grant an extension for lodging an objection. Okay, in Section 104.4, it says that a senior SARS official may extend the period prescribed in the rules within which objections must be made, if satisfied that reasonable grounds exist for lodging the objection. Now, Rule 7 provides that 80-day period for lodging an objection, all right? So in the explanatory memorandum, they point out that Section 104.4 read with this rule and Rule 52, which deals with the appeals, may create the impression that the extension can only be requested for cases that fall under Section 104.4 and not those falling under Section 104.5. Okay, so what does Section 104.5 talk about? It talks about exceptional circumstances, all right? Periods going on beyond that 80-day period, exceptional circumstances, etc. So the proposed amendment wants to clarify the matter by aligning the wording of Section 104, which deals, as I say, with your objections and grounds for extension for submission of objections, with Section 107, and Section 107 deals with appeals. And so Section 107 looks fairly similar to 104, dealing with when you can appeal, what is the period within which you must lodge your notice of appeal, and so on, similar to what we say with objections. But now they've decided that they want to bring the wording more in line. So they want Section 104 to read more like Section 107. And they want to propose that the time period of the extension must be aligned with the structure used in Section 107. And that also makes a provision for a maximum period of extension and other limitations of the Act. So what we're going to see coming through is that Section 104.4 and Section 104.5, sorry, a little bit of a typo there, will be amended to read as follows. So Section 104.4 will start off looking pretty much the same, where it will say that, you can apply for an extension for the lodgement of an objection, and it will say a senior SARS official may extend the period prescribed in the rules within which objections must be made. So the extension can be made for up to 30 business days if there are reasonable grounds for the delay. So it's similar to what it says at the moment, but it's just rejigging the wording kind of more in line with the structure of Section 107. And if you want to go beyond 30 days, then it must be that there are exceptional circumstances. Okay, but you can never extend beyond 3 years from the date of the assessment or the decision that you are objecting to. Okay, or if the grounds for objection are based wholly or mainly on a change in practice generally prevailing that applied on the date of the assessment or decision. So it's not really changing the gist of what it says, but it's just aligning the wording more closely with what we see in section 107. So that's the amendment to section 104. Then we see in terms of the ADR, so alternative dispute resolution process. ADRs, normally what you do is you apply for your objection. If SARS disallows the objection, you go on appeal, and then it can be considered whether the matter is suitable for ADR. And they make the argument that ADR has proved to be an efficient way of resolving disputes between SARS and taxpayers. And so now they're thinking of bringing that ADR process earlier, not just at the appeal stage, which is where it sits at the moment, but here sort of as you going into the objection stage. So the amendment is aiming to improve the efficiency because apparently there is quite a big backlog of objections with SARS. I think many of you are probably experiencing that. And to kind of streamline and speed up the process, they're looking at introducing this ADR to allow for earlier resolution of a tax dispute through improved engagement and document exchange at the objection stage of a dispute. So in order to do that, they would have to amend section 104 by adding on 2 additional subparagraphs, okay? So after we've been through the whole process of who can object and applying for an extension for submission of your objection, and then it would go on to say that, sorry, this is jumping around again. There we go. By mutual agreement, SARS and the taxpayer making the objection may attempt to resolve the dispute through alternative dispute resolution under procedures specified in the rules. Now, whether they're just going to bring the existing ADR rules in at the objection process or they're going to introduce new rules to deal with this remains to be seen. Okay, proceedings on the objection are suspended while the alternative dispute resolution procedure is ongoing. Okay, but bear in mind that doesn't necessarily suspend the payment of the debt. You still have to apply for suspension of payment of the tax debt. All right, now whether this is a good idea or not, I guess is open to debate. Some people feel that it might just give SARS the opportunity to delay the process a whole lot more than what they're doing at the moment, because then they say, right, we're going to take the matter to ADR, and then you wait and wait and wait for a date for the hearing. And so is it really going to expedite the process, or is it just from SARS side, tick boxes, whereas from the taxpayer side, you still end up with the same amount of delay? Yeah, I mean, it remains to be seen. SAICA certainly is quite critical of this proposal, and they're suggesting that perhaps it should not go ahead. So we'll have to see what happens, whether it actually stays in or whether the pressure from the other professional bodies and taxpayers is similar in terms of saying that they don't really want this ADR process at objection level. So yeah, it's going to be interesting to see what actually happens. Now notice here that whereas with all the other administration provisions, we said that it will take effect from the date of promulgation of the Act, but this one, the effective date will be determined by the Minister by notice in the Government Gazette to ensure operational and system readiness from SARS side. So it's likely that even if they put the legislation through, that this actual provision may not become effective for a reasonable period of time until maybe a year into the future. Okay, so this is not something that will automatically initiate on promulgation date. If it does make its way into the final legislation, we'll have to wait and see what actually happens as far as that is concerned. Of course, what we really want to see is that within the existing process, we want to see that things are happening and that SARS sticks to the rules and sticks to their deadlines and fixes up what is not working properly in terms of the existing process. And I agree that maybe that should be the main focus rather than now adding on this extra cog in the wheel that may not really be in the taxpayer's best interest. Okay, section 107, and as I say, that deals with your appeals. They're looking at amending that with the addition of this paragraph that says, after the expiry of the period within which an appeal must be lodged or the extended period, the tax court may extend the period within the appeal may be lodged for up to 120 business days. So that's just an additional subparagraph that will be added in there. Because at the moment, what it says is that you can extend the period within which to lodge your appeal for 21 business days if there are reasonable grounds, or up to 45 business days if there are exceptional circumstances. And so what they're saying is that that can then be extended for up to 120 business days if the extension is in the interests of justice. I guess it's putting a number in here, because in some cases we have seen condonation at the courts, where they are condoning the late submission of a notice of appeal, and there's no specific time frame as far as that's concerned. Here they're saying up to 120 business days. Well, I think maybe I'm putting my head on the block here, but I think SARS is often the one, more often than the taxpayers, who don't meet these deadlines. So it's interesting that they're actually putting a time frame in, because otherwise at the moment, yes, the question is it in the interest of justice? But there's not a specific time frame. And so, yeah, that's what they're really looking at introducing here. Okay, and then as far as Section 109 is concerned, and Section 109 talks about the jurisdiction of the tax board. And so we see that if there's a dispute and it's dealing with amounts that are not that large and it's not too complicated, then you can have your matter considered at the tax board. But it doesn't seem to be a very popular route. And as they say in the explanatory memorandum, some taxpayers, in fact, most taxpayers, prefer to go to the tax court. They don't seem to have as much confidence in the tax board, or maybe it's just another step on the ladder that just protracts the whole thing a whole lot further. So they'd rather just go to the tax court. But SARS wants to have more dealt with at the tax board. And so they want to take this overflow of matters from the tax court and maybe have more things referred to the tax board. And so the proposed amendment aims to remove the requirement that SARS and the taxpayer must agree on a matter to be referred to the tax board, and sort of turn it around and say that the matter will automatically be referred to the tax board if it fits within the financial limit. So it would automatically be heard by the tax board unless they agree to the contrary. Okay, so it would only be referred to the tax court if both parties agree, because of the complexity of the matter or the amount of the dispute. So they want to amend Section 109 to say an appeal against an assessment or decision must in the first instance be heard by a tax board if it does not exceed the amount the minister determines by public notice, or if they agree that the matter should be heard. Okay, so it should be heard by the tax board unless they agree to the contrary. Sorry, I think I've put that across in the wrong way. All right, so looking at the tax board as a first port of call. Okay, and then going on from there, so then some other amendments coming through, and now we're dealing with tax debt and looking specifically at the temporary write-off provisions, so the compromise provisions that we see in Section 195 of the Tax Administration Act. Just want to get it on my iPad here, Section 195, so just bear with me. So, okay, so as we know, that there are circumstances where SARS can enter into a compromise to write off debt. And Section 195 specifically provides that a senior SARS official may decide to temporarily write off an amount of tax debt in certain circumstances. In fact, you'll see here that when it talks about write off in terms of Section 192, Section 192 talks about writing off a debt, meaning to reverse an outstanding tax debt either in whole or in part. That's what they mean by writing off as per Section 192. So a senior SARS official may decide to temporarily reverse an outstanding tax debt, either in whole or in part, in one of these two circumstances. If they are satisfied that the tax debt is uneconomical to pursue, and that's in terms of Section 196, and they list certain criteria that I'll show you in a moment, or for the duration of the period that the debtor is subject to business rescue proceedings under Chapter 6 of the Companies Act, as referred to. Now, this part here was actually added in 2014, talking about like writing off while the company is under business rescue proceedings. Now, that's really what they're looking at here. They're saying that when you look at this question of whether an amount is uneconomical to pursue as per Section 196, it means that the total cost of recovering the tax debt will likely exceed the anticipated recovery. And they have to consider certain factors as listed in Section 196. And that includes what steps have been taken to recover the tax debt so far, what is the amount of the debt, what are the costs involved in those steps, what is the likely cost of continuing action to recover the debt, what is the anticipated return from the action, what is the financial position of the debtor, including the debtor's assets and liabilities, cash flow, and possible future income streams. So these criteria for sort of writing off tax debt have always been there. But as I say, then more recently in 2014, they said that either if it's uneconomical to pursue in terms of these criteria, or during a business rescue process. And the amendment that they want to bring in here is to take away that paragraph B that talks about in a business rescue process, because they're saying that actually they don't need to have that anymore. They've got other ways of evaluating whether a debt is uneconomical to pursue. And so they don't want to have this situation where in a business rescue process, it's just straight on possible to write off the debt. Yeah, which is interesting that they actually want to delete paragraph B. All right, so just to take that out. So then if we go back to the wording, it will say that the senior SARS official may decide to temporarily write off an amount of debt if they're satisfied that the tax debt is uneconomical to pursue, as described in Section 196 at that time, full stop. Okay, so this paragraph B is what they're looking at taking out. Okay, whether that's going to make things more difficult for business rescue practitioners, I suspect it will, but yeah, it remains to be seen. Okay, and then we get to the rules for appointing a public officer. Now, every company, of course, has to be represented by a public officer, and that public officer has to meet certain criteria as set out in the Tax Administration Act. And in particular, we look at the Section 246, 247, etc. of the Tax Administration Act around that criteria of who can be appointed as a public officer. So if we look at especially Section 246, subsection 2, it says the individual represented has to be, and it lists certain criteria, approved by SARS, a person who's a senior official, and if no senior official resides in the Republic, then some other suitable person, etc. Okay, so these are the people who have to be appointed to represent a company. Okay, now given that companies are automatically registered for income tax on formation, it's proposed that the 1 month period, which is currently there, it says every company basically has a month in which to appoint their public officer. But they're saying that's not necessary. I mean, you must just appoint, they must be appointed at the time of registration because they're automatically registered for income tax at the time of formation. So a newly formed company will know who its directors are, and therefore they must know who the public officer is at the time of formation. And if they fail to appoint a public officer at the time of formation, then this proposed amendment is looking for a default rule which will determine which senior company officials will be deemed to be, they will be automatically regarded. So one of them, if you don't specify who it's going to be, then it will be a certain person in terms of this deeming provision. And so Section 246.2, which is what I was reading to you just now, will be amended to read as follows. The individual representative must be a person who is a senior official of the company, or if no senior official resides in the Republic, another suitable person. So that's kind of what it says at the moment. It's just changing the wording, the sequence a little bit, but it's pretty much what it already says. But it'll go on to say, and, by implication there's an and there, and appointed by the company or by an agent or legal practitioner who has authority to appoint such a representative for the purposes of a tax act and is called the public officer of the company, okay? But then they'll have the subsection 3, which is going to kick in. So currently we have a subsection 3 that says if a public officer is not appointed as required, the public officer is the director, company secretary, or other officer of the company that SARS designates. But now it's getting more specific here. Now it's going to say that if your public officer is not appointed as required, the public officer is deemed to be the first person. So it's going in the sequential. So the first person you can find on this list is the one who will be the public officer. All right, so the first person who is eligible to represent the company as public officer in the following order of priority: managing director, financial director, company secretary, or if none of those, then a director or prescribed officer who has the largest shareholding, or a director or prescribed officer who has held office for the longest period, or a senior employee in order of the company's reporting hierarchy, or any suitable person that SARS designates for that purpose. All right, so it's kind of just giving this default list of who is deemed to be the public officer if you don't specifically appoint somebody at the time of formation. All right, so it has to be at the time of formation, not this 1 month period. Okay, so the public officer must be eligible to be so appointed, meeting these requirements, that they are a senior official, etc. If the public officer is not eligible or regarded by SARS as unsuitable, then the company is regarded as not having appointed one, and then you're going to go to that list of deemed persons in this order of priority. Now, the company has 21 business days with which to appoint a new public officer. All right, so if you lose your public officer, and then failing the appointment, you're going back to this default list of who's going to be considered the public officer, or SARS can designate somebody. It's a very onerous office to hold, of course, being the public officer of a company. Also relating to the public officer, section 246(7) will be amended to say the company is regarded as not having appointed a public officer and must, within 21 business days of paragraphs A or B applying, notify SARS of the newly appointed public officer if the person appointed is not eligible to represent the company, or is notified by SARS that he or she is not considered suitable, etc. All right, and then there's various consequential amendments. So a whole lot more attention being given to this question of who can be a public officer and the requirement to appoint public officers. Remember that any person who is disqualified under the Trust Property Control Act, the Non-Profit Organization Act, or your delinquent directors under the Companies Act may not be appointed as a public officer. So if you have somebody who's not eligible to be a public officer, then you're deemed to be in a situation that you are in default, that you have no public officer. Okay, but those are the amendments coming through there. So that really is the whole list of administrative amendments. Now, the one that I haven't specifically mentioned that you might wonder why I haven't, because it's not in the Tax Administration Laws Amendment Bill. It's actually in the Taxation Laws Amendment Bill, and it deals with the claiming of your input tax credits. And it's an amendment that is going to amend Section 16. Currently, if you've got an input tax credit, you can claim that input tax credit as long as you claim it within 5 years of the date of the invoice, right? But now SARS wants to change that to say that you have to claim the input tax credit in the tax period in which you became eligible or entitled to that tax credit. Now, I think that's going to have horrible tax implications for many vendors. And yeah, so I saw that SAICA has put in a very strong submission against that amendment. We'll see whether it comes through. But to me, it sounds like an administrative amendment, but it's not in the administration amendments. It's in the Taxation Laws Amendment Bill. Okay. The representative taxpayer referred to SARS, is that the same as the public officer? Well, when we talk about the representative taxpayer, so over here in section 246, 247, we are talking about public officer. That's what's being referred to. And the public officer is the person that basically represents the taxpayer from a legal point of view. So that's the person that's going to be penalized, etc., if the company is in default. And that's the role of the public officer. But the representative taxpayer might be just the person who is the contact person. So that could be a slightly different, it's a different term that is used. So what we're talking about here is the actual official who is appointed as the public officer who does represent the company. Yeah, so I guess in that context, it is the representative. Yeah, okay. All right. Okay, so to go on to the other aspects that we're going to be talking about this afternoon, our SARS documents, there's a few SARS documents. We're going to look at interpretation note number 132. We'll have a look around the tax filing season, just a few things because we're already well into the tax filing season. Some updated binding general rulings, the dispute resolution for trust, certain enhancements there. And then we'll talk about reduced assessments. And SARS has published a guide on requesting a reduced assessment. This pertains specifically to personal income tax. Okay, so just to take note of that, but we'll have a look at that guide just now. Now, interpretation note number 132. This is entitled Persons Not Eligible to Register as a Tax Practitioner and Deregistration of Registered Tax Practitioners for Non-Compliance, and was issued on the 29th of July 2024. And it provides guidance on when a person may not register as a tax practitioner or when SARS could deregister somebody who is already registered. Notice that SARS did a little while ago also publish a guide on criteria for the registration of tax practitioners and the recognition of RCBs, recognized controlling bodies. Now I'm sure you're all aware of what the criteria is for registration and the criteria for RCBs, but this interpretation note number 134, in fact, what I'm going to do is just link onto that. Just open that in my browser here. So if we go to this interpretation note, and you'll see here that it provides guidance on when, due to non-compliance, basically a person is struck off the roll as far as SARS is concerned from being a tax practitioner. Now, what it's looking at in particular is for non-compliance, all right, due to non-compliance with the tax legislation. And when it talks about non-compliance, it talks about non-compliance in terms of Section 256(3) of the Tax Administration Act. So it does go into the whole issue of requiring people to register with SARS as tax practitioners, but then it says, and it points out here, Section 240, subsection 3 of the Tax Administration Act prohibits SARS from registering a person as a tax practitioner or to deregister if the person is non-compliant, and they're specifically looking at Section 243D, dealing with tax non-compliance. All right, so let's just have a look and see what that provision actually says. Let's just take that away and go back to my slides. So if we have a look at Section 240, subsection 3 of the Tax Administration Act, it says that a person may not register, or SARS must deregister. It says SARS may deregister. In the interpretation note, they read this as must, but here it actually says may. SARS may deregister a registered tax practitioner if the person, okay, so these are criteria where you can't operate as a tax practitioner. And you'll see it's got A, B, and then C and D. All right, so A talks about where there's been serious misconduct. So during the preceding 5 years, they've been removed from a related profession by a controlling body for serious misconduct. B talks about during the preceding 5 years, they've been convicted of theft, fraud, dishonesty, etc., for which they've been sentenced to a period of imprisonment exceeding 2 years without the option of a fine or to a fine exceeding the amount prescribed. All right, so that's fraud, forgery, etc. So then in subsection C, it talks about being prosecuted for a serious tax offense, all right, in the preceding 5 years. Now, if you want to say, well, what is a serious tax offense in terms of Section 1? I'll tell you now. A serious tax offense is defined as a tax offense for which a person may be liable on conviction to imprisonment for a period exceeding 2 years without the option of a fine or to a fine exceeding the equivalent amount of a fine under the Adjustment of Fines Act. So it's basically a criminal prosecution when we talk about a serious tax offense, okay? So if you've been convicted of a serious tax offense during the preceding 5 years, then you can't be a tax practitioner. And then D talks about tax compliance. All right, so all these other things I've spoken about, A, B, and C, are not what's covered by the interpretation note. The interpretation note is specifically looking at Section 243D, which talks about tax compliance. So it says if this person has been non-compliant for at least 6 months out of the preceding 12 months. Again, that talks about for an aggregate period. So you might be compliant and then non-compliant, then compliant and then non-compliant. But if I look back, if I put a stake in the ground today and I look back for the last 12 months, has this person been in a non-compliant situation for an aggregate period of at least 6 months out of the last 12 months? That's what it's looking at, okay? But it's not just that. There's other criteria that come into play as well. But if that has happened, that you've been non-compliant for at least 6 out of the last 12 months in aggregate, and they've failed to demonstrate that they've been compliant for that period, or they have failed to remedy the non-compliance. All right, so it might well be that you were non-compliant for more than 6 out of the last 12 months, but if you have remedied the non-compliance, then that's not a ground for being deregistered as a tax practitioner. So if you've failed to remedy, if you were indeed non-compliant and you failed to remedy the non-compliance within the period specified in a notice by SARS, then that's when you could be deregistered as being a tax practitioner. All right, so this interpretation note talks about the steps that SARS will take. So if they identify that a person has been non-compliant for at least 6 out of the last 12 months. And this can be a rolling thing. It's not just at the end of each year of assessment. It can be on a rolling basis. They pick up so that someone has been non-compliant. They would then issue a notice to that person pointing out that they've been non-compliant and giving them a period of time within which to rectify, maybe in the next 30 days, whatever the case might be. If the person rectifies the situation, then they're no longer in default as far as this provision is concerned. Or if they are able to show that actually they were not in non-compliance, they were okay, then they would not be in default. Okay, so it's only if they have been non-compliant and they have failed to either correct the non-compliance or remedy the non-compliance or show that they were not non-compliant, then if they're not able to do that, then they would be deregistered. So there's steps that are taken. It's not a case of as soon as you come up on the red button that you're going to be deregistered by SARS. You basically have a period in which to fix this. But I think the key thing is that if you get a notice from SARS querying your compliance, don't just take it lightly. Make sure that you attend to it and deal with it as a very serious matter, because you do not want to end up in a situation where you have been deregistered by SARS as a tax practitioner, because it means that during that period of time, you cannot operate as a tax practitioner. And that means that you can't be submitting any tax returns on behalf of somebody and charging them a fee. You can't be representing people with SARS. So you basically lose your business, and you probably lose quite a bit of reputation in the process if you are deregistered as a tax practitioner. So you don't want that to happen, but it's not something that's going to happen easily. The axe is not just going to fall. There would be some sort of notice period that's given by SARS within which, but the key thing is don't ignore it. Make sure that you deal with it. Now, of course, it says here, it talks about being non-compliant in relation to section 256.3. So let's just have a look at section 256.3. How does that measure our compliance? So you'd be non-compliant as measured against this benchmark of compliance. Now, this is very similar to when you're looking for tax compliance status with SARS for any person. They will say, are you registered? Do you have any outstanding tax debt? And is there any outstanding tax return? Okay, so you have to be registered. You must have no outstanding tax debt other than tax debt that either is under management with SARS. You might have an installment payment arrangement, or you might have a dispute with SARS where you've applied for suspension of payment under section 164. And of course, you have that covering over you from the time you apply for suspension of payment with your, and you're going to be entering into a dispute until the time that SARS basically rectifies the dispute or agrees that you've lost the dispute, and for a period of time after that, they can't take steps to recover. So that's the recovery covering under section 164.6, or you've got an amount of debt of not more than 100 Rand. Okay, so that you've got no outstanding debt other than these amounts. An outstanding tax debt means that you've got a debt owing to SARS and it's been outstanding beyond the due date for payment. So if your due date for payment was the end of August and you're now into September, you've got outstanding tax debt. All right, unless it falls into one of these criteria over here. And no outstanding returns unless an arrangement has been made with SARS for submission of the return. Okay, so the compliance status is looking at those three things: registration, tax debt, and returns. But now, of course, you do need to think about if you have a VAT return that is outstanding, that would put you into a non-compliance situation. And you might have your VAT return going in late. So for 15 days or however late it might be, you're non-compliant. Then you submit the return, you're back to being compliant again. But then next month, you're non-compliant again. So if you end up submitting your VAT return late every single month, depending on how long outstanding it is, it could put you in a situation where you're non-compliant for 6 out of the last 12 months. But remember that if you have remedied the non-compliance, then SARS cannot deregister you under this particular subparagraph. Okay, all right, so just take note of that. Be careful of that. If SARS queries or sends you any notice around your tax compliance as a tax practitioner, don't take it lightly. Make sure you act on it quickly to make sure that you don't end up in a negative and precarious situation as far as your tax practitioner registration is concerned. Okay, 2024 filing season, well, we're well into it by now because it started beginning of July. And of course, non-provisionals due in October, provisional taxpayers and trusts due in January. The notice of who has to submit a return, that was covered. We actually did this in our previous update, but it was covered in this notice in the Gazette, which was then corrected. But the correction wasn't anything that would change the gist of the requirement of who has to submit a return. It was just the stipulation there around the tax threshold. They put last year's number in. But yeah, so they specify who has to submit a return. And so if you are in a situation where you're not sure if somebody has to submit a return, have a look at the Gazette and work through that to see that it clarifies very clearly for companies, individuals and trusts, residents and non-residents, tax-exempt entities, and so on, exactly who has to submit a return. So it's a very important notice to be aware of. If SARS levies a penalty, and remember that's a fixed amount penalty for non-submission of tax return, if they submit a penalty or they levy a penalty and you want to challenge that penalty on the basis of not liable, then you want to be referring to this notice in the Gazette. If you're saying my client was not required to submit a tax return because of XYZ, it would be in terms of the notice as published in this Gazette. Okay, they do have a lot of information on their tax season website, which you can just go to quickly over here. And you'll see that this is updated quite regularly. And they give you due dates for the filing season, all right, 21st of October for your non-provisionals, 20th of Jan next year for your provisional taxpayers and any trust, whether provisional or non-provisional, they are due the 20th of January. Okay, and as I say, they do update this from time to time. They have explained here about the auto-assessment process for this year. And if you don't agree with the assessment, remember that with auto-assessment, the taxpayer is still liable for ensuring that SARS has the correct information. So I'll go over the exemption of when you don't have to submit a tax return relating to an auto-assessment, but it's only if all of the SARS information is 100% correct. So if there's anything that's incorrect or incomplete as far as the SARS information is concerned, then you have to submit a tax return, and you do that by going into e-filing. Even if you've been auto-assessed, you still go into your e-filing, complete the return, submit all the necessary information, and you have to do that by the normal due date, so end of October. All right, if your auto-assessment is issued after the 21st of October, which is unlikely because I think they've pretty much issued all the auto-assessments by now, but if it does come out after the 21st of October, you've got 40 business days to submit all the correct information to SARS. Okay, so as far as your auto-assessments are concerned, the exclusion in this notice, let me just take you back here, this notice in the Government Gazette that specifies who has to submit a tax return In that notice, paragraph 3 talks about exclusions, people who don't have to submit a tax return. And paragraph 3.3 speaks to the auto-assessment exclusion. And so it says a natural person is not required to submit an income tax return if notified in writing that they're eligible for auto-assessment, and that would be effectively they issued with an auto-assessment, and the person's gross income, exemptions, deductions, and rebates reflected on that auto-assessment, and therefore reflecting what's in SARS records, are complete and correct as at the date of the assessment, to give effect to that auto-assessment. So if everything is 100% correct, that's fine. You can accept the auto-assessment. In other words, you don't do anything. You just accept the assessment that has been raised by SARS. But if you know that there's anything else, any other income that you might have received, so SARS auto-assessment might show the person's salary, interest, things that come through from the bank and so on, but maybe they don't know about the rental that this person's getting from renting out their holiday house down at the coast. So then their information is not complete and accurate, and therefore you're not eligible for the exclusion. Therefore, you have to submit a tax return, and you would then have to go, as I showed you just now, into e-filing and submit the necessary tax return. So please do impress upon your clients that they are still liable to submit a tax return unless they are eligible for this exclusion. Okay, and that means if they're not eligible for the exclusion and they don't submit a tax return, they're going to end up with your fixed amount penalties for non-submission of a tax return, and that can kick in, you know, way down the line, and it can obviously accumulate, because basically it's for every month that that tax return is outstanding, you get another fixed amount penalty coming in. So it can end up being a very significant amount of money at the end of the day. All right. The filing deadlines I showed you on the SARS website when we went there just now, so we've covered that. Then I just want to talk about the dispute resolution for trusts. So SARS has announced on their website, and we'll just have a look at it here as well, that they've made certain enhancements to the dispute resolution for trusts. And that basically talks about submission for request for reasons, request for remission, and notice of objection and notice of appeal applying to trusts. So previously the trusts used the ADR 1 and 2, and now they are basically part of the normal dispute resolution process on e-filing. And the process for suspension of payment, that still remains a manual process, and it requires you to upload a formal request letter when lodging a dispute on e-filing and submitting a formal request letter at a SARS branch. Okay, so this is a new, in other words, the normal process that applies to other taxpayers has been extended to trusts, and that's from 20th of April 2024. So if you submitted any of the processes before that date, you should still carry on your dispute through the manual process. But from that date onwards, it's now an automated process for trusts as it is for other taxpayers. Okay. Then SARS recently issued this guide for a reduced assessment. And I just want to go back and pick up the link that I had over here. A little bit further back. Here. All right. So they issued this guide on applying for reduced assessment. Okay, it's this one over here. Again, 24th of June 24. Submit request for reduced assessment on e-filing, the RRA01. And they make the point here that this guide provides steps on how to complete and submit the RRA01 form if a taxpayer wants to request SARS to reduce an existing assessment. And this applies to personal income tax assessments only. Okay, so only to PITs. Okay, so what I'm going to do is just basically go through a bit of a summary of what is in this guide about applying for a reduced assessment. So they make the point that SARS can reduce an assessment in terms of one of these provisions of the Tax Administration Act. Section 93(1)(d) provides that if SARS is satisfied that there's a readily apparent undisputed error, either in the assessment issued by SARS or in the return submitted by the taxpayer, then they can issue a reduced assessment. Section 93(1)(e) says that if SARS is satisfied that an assessment was based on the failure of an employer, in other words, third-party information was incorrect, or there's been a processing error by SARS, or a fraudulent return submitted by a person who's not authorized by the taxpayer. So in these circumstances, also circumstances where SARS can issue a reduced assessment. Okay, so basically any of these circumstances as listed would be circumstances when SARS can issue a reduced assessment. So we are looking at Section 93, again, going back to the provisions in the Tax Administration Act that deal with assessments. We spoke about this earlier, the different types of assessments that SARS can issue. Section 95 spoke about the estimated assessment. Section 91 spoke about the original assessments, and now Section 93 talks about reduced assessments. Okay, now it does also provide for reduced assessments in other contexts, like when you're successful with a dispute, or you have a settlement with SARS, etc. But these are the two particular things that are covered in the guide. So when does SARS issue a reduced assessment if there's a readily apparent undisputed error? What is a readily apparent undisputed error? And also this issue around incorrect information from third parties or a processing error by SARS. That could be where an assessed loss balance maybe has not been set off, or a fraudulent return submitted by a person not authorized by the taxpayer. So the point here is that you would be going and asking SARS to issue a reduced assessment without having to go the objection route. And that's the beauty of the system. This process is that you don't have to go through the dispute resolution process. In these circumstances, you can ask SARS to issue a reduced assessment. So the guide says that it allows taxpayers a less formal mechanism to request SARS to amend an assessment without having to follow the objection and appeal route. The request to reduce an assessment, that RRA01 form, does not replace the process altogether, because that option is still open to you, all right? But it does give you this interim, less formal method to resolve errors, okay? It's like a request for correction, but it's a slightly different process, okay? And it only applies to your personal income tax assessments. Now, bear in mind that there is the prescription rule in terms of Section 99 of the Tax Administration Act. So if an assessment has prescribed, so the 3 or 5 years, then you're not going to be able to apply for a reduced assessment. But you can submit a separate RRA01 in terms of Section 93(1)(e), okay, because Section 93(1)(e) is basically where this error is caused by other people, okay? So Section 93(1)(d) talks about where there's a readily apparent undisputed error by SARS or the taxpayer in a return, whereas Section 93(1)(e) talks about where SARS has raised an assessment, or there's been an assessment based on incorrect third-party information or a processing error by SARS, or somebody else fraudulently submitting information without the authority of the taxpayer. Okay, so there you can still apply a separate RRA01. So the Tax Administration Act says, in terms of the prescription rules, that the prescription does not apply if it is necessary to give effect to an assessment referred to in 93(1)(d), okay, readily apparent undisputed error, if SARS becomes aware of the error before expiry of the prescription period for that particular assessment. So if SARS becomes aware of the error within the 3 or 5 years, then they might still go beyond the 3 or 5 years in terms of issuing the reduced assessment, but they became aware of the error within the prescription period. They can still then issue a reduced assessment. Or the other time when the prescription rule does not apply is basically under Section 93(1)(e). So that's quite important to bear in mind, because often these prescription rules can be, can pose quite a problem for taxpayers and their clients. So it's important to remember when the prescription rule does not apply. Yeah, so the RRA01 can be submitted through e-filing. Okay, and I think you'll see that in the guide. It makes it possible, but only for personal income tax. Okay. Now, SARS on their guide on dispute resolution. What about the objection? How does that fit in? Well, you don't always have to object, and this reduced assessment mechanism just basically gives you a simpler mechanism to get a reduced assessment. And it's a good process to use, especially if you consider the relaxation on the prescription rules that come through in terms of section 93(1)D and 93(1)E. Okay. Let's look at this example here. A taxpayer forgets to claim retirement annuity fund contributions, and they've got the required certificates. SARS assesses the taxpayer, and then they agree, yes, in fact, you did make an error, and you can fix it by way of a reduced assessment. So this is an example that comes from the SARS guide. Okay, so you would follow the request for correction, now the RRA, you would follow the RRA procedure in terms of getting a reduced assessment in that particular case. Okay. Now, if you omitted income to the prejudice of SARS, they say, SARS may not always believe that this was simply an error. For example, if the taxpayer only requests a reduced assessment after the taxpayer's return is being verified or audited, SARS may believe that the omission was not onerous and was not erroneous, and the taxpayer would then have to go the objection route. Okay, so, but it's worth trying the RRA process first before you do the objection route, if it fits within the ambit of section 93(1)D and section 93(1)E. All right, so how does this process work? So as I say, section 93 enables SARS to alter an assessment if it's based on a processing error. This just comes from SARS guide on the dispute resolution, which actually predates this the request for reduced assessment guide, but it gives the general framework for reduced assessment. The section enables SARS to reduce an assessment to rectify errors even when no objection has been lodged. A formal objection need not be filed if you fit within section 93(1)D and E, because SARS can then do the reduced assessment if they're satisfied. But remember, just to remind you, section 93(1)D talks about a reduced assessment when there's a readily apparent undisputed error by SARS or the taxpayer, and section 93(1)E talks about where an assessment is based on third-party information that was incorrect, or a processing error by SARS, or somebody else has submitted a return on behalf of the taxpayer without the authority of the taxpayer. So that's when you'd look at going for the reduced assessment. Now, way back in 2015, they had this amendment to section 93(1)D talking about a readily apparent undisputed error. And their explanation then was to say that it's inserted to allow taxpayers a less formal mechanism to request corrections without having to follow the proper objection and appeal route. But now taxpayers have attempted to use these requests that should actually go through objection, and therefore they tightened up on the wording. Okay, that SARS must be satisfied that there's a readily apparent undisputed error in order to qualify. So what do we mean by readily apparent undisputed error? Well, SARS had a draft interpretation note in 2021, haven't finalized it, but in that draft interpretation note, they said that a readily apparent undisputed error would be clearly visible and identified without any hesitation or difficulty. So I guess if you go back to my example with the retirement annuity fund contributions that were not claimed, it's very easy to submit the certificate. Here it is. And SARS, I'm eligible for this deduction. So it's clearly visible, no hesitation or difficulty in saying, yes, you should get it, and then they can process it. Okay, so there's no complexity in terms of interpretation or calculation. It's clearly visible and identified without hesitation or difficulty. So at the first, this is what they say in the draft interpretation note, at the first glance of the request, SARS must be able to easily determine that there's an undisputed error. The presence of any doubt will disqualify the request for reduced assessment. Then you would have to go the objection route, because then it's subject to closer scrutiny from SARS. So the error must be obvious and unquestionable. If SARS cannot make this determination by merely looking at the return or assessment, the error cannot be said to be readily apparent, although there might well be an error. So yeah, it's a good process to use, but make sure that you fall within the ambit of this provision. Undisputed, remember, it must be a readily apparent, okay, we've covered that part, undisputed error. So undisputed means, of course, not questioned or disputed, must be accepted by SARS, and all the facts submitted by the taxpayer are proved to be correct. At the same time, they also not be readily apparent, since to prove the error may involve a high degree of verification. Then that's probably going to have to go the objection route. The confirmation of the error should require no more than a simple verification and not be interpretational. Okay, so certainly not interpreting a tax treaty or something like that. A factual dispute of the error will disqualify the request. So, it must be a readily apparent undisputed error as mentioned. Factual undisputed errors are by their nature objective, and if readily apparent, may fall into section 93(1)(d). The burden of proof lies with the taxpayer, who must satisfy SARS that a readily apparent undisputed error was made by SARS in an assessment or a taxpayer in a return. Okay, so it is a very useful route to go if you fall within section 93(1)(d) and E. And also remember that, you might, even if it's a section 93(1)(e), then you might even get a little bit of leeway as far as your prescription period is concerned. Error is a mistake. Okay, so I've given you on the slide here. I don't think we need to go through this in detail. But an error is where you've put something into a return and you've put it there. There's a mistake in a return. Notice here they say an error by a taxpayer is limited to an error in a return, not an error in the accounting records used to complete the return. An error in the accounting or tax records would require more than just a simple verification to confirm the error. Therefore, it would not qualify under 93(1)(d), as it would not be readily apparent. Okay. And an error is not the same as omission. The omission of information does not fall within the ambit. Okay, so that was in the draft interpretation note. As I said, that hasn't been finalized yet. Hopefully it will be finalized. Remember the onus on the taxpayer, okay, and they've given two cases here in the draft interpretation note. Rampasad said that only if SARS is satisfied that there's a readily apparent undisputed error, may it reduce the assessment. The first hurdle for the applicants is to show that the errors were in fact readily apparent and undisputed. Okay, and then GB Mining said the error has to be proved to the satisfaction of the commissioner. To discharge this burden of proof, the taxpayer must place information before the commissioner to substantiate the error. Now, notice here, these dealt with, well, certainly GB Mining was a company. So, section 93(1)(d) and E can apply to other taxpayers other than personal taxpayers. It's just that this process that SARS has introduced and the guide on the request for a reduced assessment process only applies to personal income tax returns. But other taxpayers can benefit from this, but then they're not covered by this simple online process that has been introduced for personal income tax returns. Okay, and I think, that brings me to the end. So 2:15, if there are any questions, please feel free to pop them into the chat box and I will endeavor to answer them. In the meantime, just to say thank you all very much for joining. I hope it has been a very useful and informative session for you. Lots of food for thought, lots of things to consider, but most of all, wishing you well for the rest of the next few months until I see you again in November for the year-end tax update. And good luck for the rest of the filing season. Thanks for joining this afternoon. I'm going to hand back to Stan. Thanks very much. Bye.
Thanks, Jackie. I don't know if there are any questions. Wait a minute and let's see. I think you basically covered everything, in my considered opinion. Danny, you wanted to say anything?
No, just logging on and just to check here to see if anyone has any questions. I don't see anyone putting any hands up. If you want, because I could also do that if you, but quite shy, you can always email us and we can pass it on.
That's fine. Okay, so Jackie, thanks very much. Thanks to everybody for joining us.
Let me just check. Someone kept putting his hand up earlier. Let me see if he wants to talk and see if he can speak his question. Hold on. Someone are putting.
Denver.
Hi, Denver. Can you hear? We can hear you. Do you want to speak your question? Oh no, he's muted himself, so I don't know. Denver.
Can you hear me?
Yeah, can you hear you now? Can you hear Jackie?
Yes.
Yes, I can hear.
Yeah, I was just trying to on the first topic that you discussed, the one on coronation.
Yes.
I was just trying to spin my head around. If you look at because I've compared the coronation case to the Oceanic Trust company. I don't know if you're aware, you're familiar with that case to 2012. And I'm just trying to compare the decision taken in coronation compared to the Oceanic Trust decision that was taken by the court. It's similar to the setup how the company is working in Oceanic Trust. They formed a trust in Mauritius, and that trust, in fact, Oceanic Trust, they were the original trustees of the trust that they formed in Mauritius, and that trust in Mauritius, actually, they were a reinsurer, and they dealt with a company in South Africa, which they sort of reinsure insurances, and the premiums was paid from the South African company to that Mauritius company trust, actually. So the outcome on that case was that, and I'm just trying to compare to this coronation one, where SARS actually said that the company or the trust that was formed in Mauritius, it had its place of effective management was in South Africa, but the other point was also the income that it sourced in South Africa. Now, I thought that the Mauritius trust, the source of income, as SARS have indicated, came from South Africa, and if I compare it to coronation, it's almost similar. And what threw me out was on page 5 on the coronation one, where you said the subsidiary had outsourced primary operations. So what does that mean? I think you've mentioned that definition there, or you've explored further on what is meant by the subsidiary outsourced primary operations, as SARS has indicated in the coronation case. So this is where I'm just trying to get my head around. That's the first point. The second one, if I look at your under judgments, bullet 3, and 4, where it talks about all non-core functions, such as investments, administration, and court custodial functions are outsourced. That one, and then the SCA comments on the primary business function. I'm just trying to ascertain investments there and the administration, isn't that the same as the primary business functions that were performed under the coronation one?
Okay, yeah, look, I haven't recently read the Oceanic Trust case, and I think it's dealing with a slightly different aspect, because the Oceanic Trust case is basically looking at whether there's where the place of effective management is. Okay,
yes,
this is a different issue to what we're looking at here. But what I can, in terms of the coronation case, so the key issue was whether they had outsourced their primary operations. And the SCA said that they had, but the Constitutional Court said no, they have not. The primary operations are actually the operation as a trust, as a fund management company, which is a broader covering than just investment management. What they had outsourced was investment trading, marketing, administration. But the broader issue, the primary function was fund management, the overarching fund management. Okay. So whereas the SCA seemed to just hone in on the specific things and saying that's their primary operations, but the Constitutional Court said no, the primary operation is the fund management, which embraces these different things. So these specific tasks that have been outsourced, the fund managers are still maintaining responsibility for those tasks, etc. And therefore you haven't outsourced your primary operations. Your primary operation is the oversight, the overall fund management. So yeah, I don't want to get into too much of a discussion. You know, we could compare to the Oceanic Trust, but the Oceanic Trust, of course, is a different issue. That's talking about place of effective management and the source of income as far as that's concerned. So it's kind of a different issue. I don't think that it fits within the scope of what we're talking about here.
Okay. No, that's fine. Thank you.
Okay.
Okay, everybody happy? In which case we'll conclude finally with a thanks to everybody for joining, those that are left of you, who haven't left yet. And Jackie, as usual, thanks for an interesting afternoon. A lot of my questions have been answered. And we'll see you next time. Just wish the Jewish clients, customers in the fraternity who have come getting Rosh Hashanah and Yom Kippur. I wish you a Happy New Year and a meaningful fast. And we'll see you next month at the next seminar, which is in October, and then which is on IFRS. And then we'll have Jackie back in November for another interesting afternoon. So once again, thanks very much and good afternoon.
Thanks very much. Bye-bye.
Thank you, Jake. Thank you.
Bye.
Yeah, just to note, so the IFRS will be a double header, so it will be a nice longer session, but you'll see those notes when they come out.
Okay.
Right, thank you, everyone.
Thanks, Ed. Bye.
Bye.